are very, very specific exclusions, but I will be explaining these without further ado because we are on the right of withdrawal. Now, as I said, we see many, many mistakes related to the right of withdrawal, traders not being aware of this right, and then there are complications related to that. So, the right of withdrawal allows the consumer to cancel without justification the consumer contract within 14 days after he received the goods or after he concluded the contract for services. I will go into more detail about this. Consumers have the right of withdrawal from consumer contracts concluded at a distance and outside business premises. So the right of withdrawal does not apply if you went into the business and you purchased something, but it applies always when there is distance. So the consumer was not the idea behind this is that consumer does not have the same sort of visibility, can check certain products directly, can handle the product. So the 14 days is applied because to give the consumer the benefit of not being able to conduct the purchase on the premises. But at the same time, there are provisions um, for diminished value in case of mishandling. So there are certain specific areas where the consumer, if can be proven that the consumer has mishandled the product, if the consumer has used the product and then wants to return it, then there is a provision for traders to be able to apply a fee in order to diminish what the consumer will be getting back, or else exclude the consumer from being able to apply the right of withdrawal. Okay, so what is off premises? I think we have covered this. So this is the list of exceptions. Where the service has already been fully performed, you cannot apply the right of withdrawal when it is obviously a service. So if I have booked, I don't know, online to get my hair done or to have someone come fix something at my house, and this person comes and he performs the service, then I cannot withdraw from my right because the service has been fully performed. If this relates to the supply of goods where the price has market fluctuations as well, obviously because of the value of the market fluctuations, these are very specific goods. If the service is clearly personalized, so if I have acquired a garment, I have made alterations which are very specific to me, I will not be able to withdraw because that is something that is very personalized. Goods that expire, goods that deteriorate or expire rapidly. Sealed goods which are determined health and hygiene, because of health and hygiene. Now here I need to explain a little bit more. The right of withdrawal and these exceptions, these need to be treated as exceptions, not the rule. For instance, there was a case that I have researched not too long ago, which was very interesting. Someone purchased a mattress online. Upon delivery, this person tried the mattress and they felt that this mattress was not comfortable enough. And they told the consumer that since they took out the mattress from its packaging due to hygienic reasons, they will not allow the consumer to benefit from the right of withdrawal. The way the court ruled was against the trader. The court said that even though the consumer has taken off the packaging from the mattress, it still is not an excuse on the trader to keep the consumer from making use of the right of withdrawal because of two reasons. Number one, when you go to a hotel, when you go to a place where obviously the bed is used by multiple people, the bed can still be used. So even though the seal, let's say, of the bed has been broken, the court said that it can still be used. And the court also said that there is a market for second-hand mattresses, and the trader is still able to sell in a second-hand at a second-hand quality. Now, the court also ruled, however, that the trader is entitled to charge the consumer any loss of quality. So if this was given to the consumer as a pristine, brand new mattress, and the consumer is returning it in second-hand quality, then the trader can make an assessment which both the trader and the consumer need to agree to, ideally, and charge the difference. I have seen some questions which relate to what I am talking about. If it is still not clear, please feel free to ask again. There are some things I will be going through on the right of withdrawal further on. When you are unsure of whether a specific good related to the seal would be eligible as an exception for the right of withdrawal, we can discuss this in more detail, and we can also rope in the MCCA to say, yes, this good qualifies as an exemption for the right of withdrawal, because if you break the seal, you cannot sell it again. In some cases, this relates to food items. So if you break the seal of certain food items, which wouldn't then be packed once again inside the first seal, then you cannot sell it to someone else. Okay. In order to make this is very important, in order to make the right of withdrawal effective, the trader has the obligation to inform the consumer about its existence and modality. If you do not have this within the agreement that the consumer is doing as part of the purchase, and you have clearly shown that the consumer has agreed to it and knows about it, it is like you have not informed the consumer about the right of withdrawal. And before I go on the repercussions, I'm going to explain what needs to be provided in terms on the right to withdrawal. So the conditions on the right to withdrawal, so how it is going to work out, the time limits of the 14 days, I will go into a bit more details about that, procedure of exercising the right, any costs in case of returns. So the consumer needs to bear the cost of returns when applying the right of withdrawal. You need to make this clear, otherwise the trader will need to bear the cost. The proportionate cost of usage. So if you are giving the consumers, and these obviously needs to be not just one-sided, they need to be balanced. If the consumer uses something, handles something more than necessary, when it is, I don't know, if I have a mug and I decide to use this mug, if I decide to drink from this mug and then I put it in my dishwasher, and you can prove that there was use, you are able to charge a proportionate cost for usage. In case of exceptions to the right of withdrawal, so you need to make the consumer aware when these exceptions apply, and the model withdrawal form, which must be durable. This is the model withdrawal form. This is an example. This is something that you will also find on the consumer law website that I mentioned before, consumer.ready. It's consumerready.eu, I believe it is the website, but I will go through it once again at the end of the presentation. And this is, it does not need to be a snapshot of this. This shows you what information must be contained in the withdrawal form. Okay, so it's www.consumerlawready.eu. Calculating the time period for withdrawal. Now the key number here is 14, as you will see. So the right of withdrawal applies for 14 calendar days. If the end of the 14 calendar days is a Sunday or a public holiday, then the end will be the following day. So it would be 15 actually calendar days instead of 14 in this case. For sales contracts where there is something that is being delivered, 14 days from the moment the good is in the physical possession of the consumer. So if I have bought something, I don't know, 15 days ago, and I receive it 15 days after the right of withdrawal starts, so 14 days starts on the 15th day when I have received the good since the time of the order. In case of multiple deliveries, the 14 days apply from the date of the last delivery. So if I bought a specific item and the delivery will be within a number of days, the last day applies. The consumer then has another 14 days. So after receiving it, I have 14 days to think about it and see if I want to keep it or if I want to terminate my contract. 1 second. And then I have, if I decide to return the good, if I decide to terminate the contract, I have another 14 days from informing to send the good back. The service or digital content, the 14 days start immediately from conclusion of the contract, obviously, because the consumer then has immediate access to the service or the digital content. On mixed contracts, so whether they are digital, physical, and things like this, it applies on the predominance, the primary scope of the contract. If it is more related to the physical good, the physical goods rule will apply. If it is related to an online good, which I have access immediately, then the online good will apply. So in case of failure to inform the consumer of the 14 days withdrawal period, it will automatically be extended to 1 year and 14 days. If you forget and remember within 12 months, you are to inform the consumer as soon as possible about the rights, and the 14 calendar days start from the date of information. Now, obviously, here we have to bear in mind that if the 14 days cooling off period, if the 14 days withdrawal period never featured in your contracts, the moment that you make the consumer aware, these 14 days will start, and the consumer is within their full right to withdraw from the contract as soon as they know that they have the opportunity to do it, as if they had it in the very beginning, okay? Not doing this, however, on the other hand, will risk that the consumer might say, listen, I did not know about the 14-day withdrawal. I am still within my 1 year, 14 days, and I want to withdraw from the contract. If you cannot prove that the consumer knew about it and agreed to it, you obviously are subject to that risk. So this is where we have a look at how the Maltese law applies. The different member states would have different ways of dealing with it. So the Director General of Consumer Affairs within the MCCAA, which I mentioned before, may impose administrative fines of not less than 500 euros and not more than 47,000 euros on any person who fails to comply with any of the provisions of these regulations. Okay. This, as I said, while the conditions of the right of withdrawal are harmonized across all member states, sanctions may vary. So if you are dealing with a consumer in another country and you have breached their right of withdrawal, the sanctions might vary according to the law in that country. So how can the consumer withdraw from the contract apart from the form that we mentioned already? It is really and truly up to the consumer how they choose to withdraw from the contract. So you will make the information available, you will tell the consumer how they can withdraw from the contract, but it is still up to the consumer to decide. But the statement of the consumer must be very clear that they are withdrawing from the contract, okay? The use of the model withdrawal form is there to ease things for traders and consumers and make sure that the necessary information is provided, but it is not obligatory. It is a good practice, however, to make it available. Simply returning the good is not enough. Okay, so if you receive the good and you have not received clear instructions from the consumer that they intend to withdraw from the contract, then that is not enough. Okay, so the consumer, if the good arrives after the 14 days and the consumer is no longer in time to make a clear statement, then the right of withdrawal would have elapsed. Use prior to withdrawal. So prior to withdrawal, prior to the consumer withdrawing from the contract, it is not allowed to use the product if they intend to withdraw. Okay, they can inspect and test the product to the extent that is necessary to establish the nature, characteristic, and functions. So you might say this might be very subjective. Someone would want to test it one way, someone would want to test it in another way. The general condition related to this is that it is as if they are testing it within the shop. So if you are looking at a phone within the shop and you are seeing how it functions, you are going through the different areas, it is not like you have opened it, you have put in your SIM card, you have tested it, and you have used it. So that is something that is completely different. It is only to be able to handle it as much as you need to see if you like it and in order to make a decision for purchase. Burden of proof of diminished value and costs of verification are on the trader. Okay, this is unfortunately very burdensome, but this is how the law is. The trader needs to provide proof that the consumer has handled the product more than necessary, and therefore, as a result, there is diminished value. Obviously, only when there is diminished value, not in case where the product might have potentially been used and there is no proof for it, and there is no, at the end of the day, diminished value. Remember the case of the mattress, only when there can be proof of diminished value. The cost of verification of this diminished value, if there are any tests that need to be conducted, if there is an engineer that needs to be engaged, those are on the trader. In case of diminished value, traders are allowed to reduce the amount to be refunded. So when selling over a website, how can you inform the consumer? Is it enough having it written on the terms and conditions on the website? For every contract that the consumer enters into, these terms and conditions that you have on the website need to be replicated, obviously, providing the necessary details as explained, and not letting the necessary details getting mixed up with all the other maybe unnecessary legal details and things like that, which would go in possibly general terms and conditions on a website. These need to be presented to each and every purchaser on a website, and they confirm that they have agreed, and a copy of these is sent to the consumer so they know what are the conditions. So refunds. When they exercise their right of withdrawal, the consumers are eligible for a refund. The refund needs to be in full, including price, taxes, and delivery costs. Refund must be done using the same medium used for payment. So if someone has paid in using a visa, they have to be refunded in the same visa unless otherwise agreed. Takes place within 14 days from receiving the notice of the decision of withdrawal. So if you remember correctly, I said that 14 within the 14 days, the consumer has to decide whether they want to withdraw in the contract. Once they make the official communication, the clear communication, then there are 14 days for the consumer to return the product. Within those same 14 days, you have you should refund the consumer for the right of withdrawal, but the refund can be withheld until the trader receives the good or the trader receives proof that good has been sent back, whichever is the earliest. Now, a refund related to the right of withdrawal specifically, okay, not any other purchase, a purchase that is conducted in these specific methods and is eligible for the right of withdrawal. Voucher refunds are not acceptable. It has to be in the same medium that someone has made the purchase, and you have to give them the equivalent exactly back. Okay. So, guarantees. There are two types of guarantees, and these get mixed up a lot. There is the mandatory guarantee and the classical 2-year guarantee, and that is the guarantee that applies in all circumstances by law. The guarantee that the business may offer can be over and above that guarantee. But you cannot say that the 2 years don't apply and only 1 year applies and then the business is offering an additional year. No, the 2 years is the basic guarantee and the business can put up an additional guarantee, a commercial guarantee. You cannot, in fact, limit or completely exclude guarantees, which is illegal. The only exclusions were guarantees which may be applicable are for water, gas, and electricity, and consumer services, plumbing, gardening, etc. Having said this, incorrect installation is still covered under the guarantee. So the general understanding is that when something is bought by the consumer, it is in conformity. Okay, it is in conformity, that it is in a good state. The good is considered to be in conformity when it complies with the description and qualities given by the sellers. Okay, so what I am purchasing needs to be what I have actually purchased, what I have agreed to purchase, what is reflected in my contract. Are fit for any particular purpose which the consumer requires them in line with the description. Okay, so if I am, I don't know, if I am buying a cup, it is understood that I can put liquid in that cup and I can use it for drinking. The trader cannot say, but that cup, unless already specified before, the trader cannot say, but that cup cannot be used to drink Coca-Cola, if it is obviously understood that I can put whatever I want in a cup and drink it. Have qualities and performance which are normally found in goods of same type and can be reasonably expected. I think this is the key word, reasonably expected. So the good is in conformity when the functionality is in line with what is reasonably expected by the general consumer for its use, for its function. What happens in case of lack of conformity? There are two types of remedies. Okay, so that when one is making use of the guarantee because there was a defect in the product, repair or replacement, or else contract termination or discount. Now, these work step by step. So first off is the repair or replacement. If this cannot be done, then there is the contract termination or discount. The consumer may require an appropriate reduction of the price of have the contract rescinded if where the consumer cannot obtain either the remedy of repair or replacement. So the first thing that you are obliged to offer to the consumer is repair or replacement. If this can be done and you accept to do this from your end as well, then that is the remedy that the consumer has access to. If the trader has not completed the remedy of repair or replacement within a reasonable time. So if you have agreed with the consumer that you are going to repair or replace a product, but this remedy or repair falls outside what is reasonably a reasonable expectation, and ideally you would agree with the consumer that this will take, for instance, 15 days to be repaired. If it will take a year to be repaired, and it is considered that during this year it is important for the consumer to use this product, and obviously you would be providing the consumer with an unrealistic burden because you are not providing the product within the right time frame, within reasonable time frames, then yes, they have a right for a reduced price or else terminate the contract. If the trader can only provide or complete the remedy of repair or replacement with significant inconvenience to the consumer. So similarly to the timeframes, if there are specific other inconveniences, significant inconveniences to the consumer, then the consumer has a right to a reduced price or else terminate the contract. The consumer is not entitled to have the contract rescinded if the lack of conformity is minor or insignificant. Okay, so if the conformity is minor, inconformity is minor or insignificant, then the repair and remedy apply. Repair or replacement cannot be impossible or disproportionate in relation to other remedy. So the consumer cannot impose on you. You have all the rights to offer the repair and replacement to the consumer. But if there is something that in order to repair or replace, it will be much, much more costly than terminating the contract and entering into a new contract, or just terminating the contract and refunding the consumer cannot force you to repair or replace the product. Okay, we have said this. Now, seller cannot ask for compensation for remedies. Okay, so when there is a problem related to the conformity and the consumer needs to make use of the guarantee, whatever is related to the repair or replacement, such as postage, labor costs, and material costs, these cannot be borne by the consumer and must be borne by the seller. Repair and maintenance needs to be within a reasonable time frame, free of charge and without significant inconvenience. It is possible that a replacement would not be possible due to lack of availability of products. It is up to the trader to prove this. Okay, you can tell this to the consumer that there is no availability and therefore there is no other alternative but to terminate the contract. Liability. This is something that we encounter a lot. So different businesses working together, and then when a problem arises, who is going to bear the responsibility? For the consumer, what goes behind in terms of transactions, in terms of agreement, is not important. And also in terms of consumer law, it is not important. The consumer holds the trader with whom he or she has entered into an agreement liable. Then the trader can take care of its own things and seek redress through the legal system that is accessible to the trader. But the liability cannot be shifted and say, listen, I know I have entered into a contract with you, but at the end of the day, it was not my problem, it was the other trader's problem. Okay. Now, if the consumer has been made aware of the lack of conformity, sometimes you find a case where something is being sold, for instance, at half price, at cost price, because there is a bit of a defect which the consumer is made aware of. It is important that you document that the consumer is made aware that the product is not in full conformity because it has a specific damage. And in that case, obviously, the consumer cannot access the guarantee in relation to that damage. Another circumstance where the consumer cannot access the guarantee, where something has been done there is a problem in conformity due to a defect that is emanating from something that the consumer supplied. So if the consumer supplied me with items for me to dry clean, and these items have been badly burned, they are badly stained, and I advise the consumer that I cannot guarantee that the product will turn into pristine once I have conducted my service. If the goods are returned to the consumer and the consumer is not happy with the result, and you have made this clear that it is impossible for you to give the result maybe that the consumer is expecting, then the consumer cannot tap into the guarantee. In the above cases, trader cannot have committed to conformity, so you cannot say then that if you are making the consumer aware with a defect, you cannot say that this product is fully conforming, and obviously you would have created a problem for yourself if you say that it is fully conforming, because the consumer has the right to tap into the guarantee. Okay. Who should prove the lack of conformity? So for the first 6 months, during which the product or whatever it is that the consumer, the lack of conformity needs to be proven by the consumer. So the consumer has to show proof that the product is not fully conforming with the product that he should have purchased, because it is not functioning as it should be, because it cannot be used for the things that the consumer bought it and was realistically expecting to use it. Okay, so the burden of proof for the first 6 months is on the consumer. Now, from the 6 months to 2 years, the burden of proof is on the trader. So then the burden shifts. So then the trader has to prove that the lack of conformity is because something happened to the product due to use by the consumer, and not because it was defective in the first place before purchase. Now, unfair commercial practices and unfair contract terms. This is a totally different subject to the one we are talking about. And it is a totally different subject because here we are adding an extra level. This is not just not knowing or not being 100% in line with consumer rules, or not maybe agreeing or understanding the interpretation. These are clear scenarios where the trader is trying to cheat the consumer, is trying to make something appear which is not, is trying to lead the consumer in a direction which is unfair. So any act, omission behavior, or representation, commercial communication, which can be included, can include an advert by a trader which may affect the consumer's economic decision. How do these become unfair? When it prevents the consumer to make a fully informed decision. They are unclear, they're unintelligible, they are ambiguous, they are untimely. So if the consumer had a specific time in order to realize something and you sent it later on, in order not to let the consumer or lead the consumer not to believe that they are outside their time frame to benefit from something. and improper presentation. There are a number of blacklisted practices to further explain what I was saying before. So falsely presenting oneself as a consumer. Now, consumer law obviously is constantly evolving, and there will be also some developments in this regard as the law continues to evolve. So falsely presenting oneself as a consumer. So if you are making reviews for your business and you are presenting yourself as a very happy consumer, that is a blacklisted practices. Claiming to be part of the code of conduct, and this code of conduct does not exist or is not true. Displaying a trust mark, quality mark, or equivalent, which is not really of your business. Claiming that products has been approved or endorsed, luring consumers well knowing inability to supply what is promised. Okay, so that you conclude a contract with the consumer when you well know that you are not in a position to supply this product or service. Make it sound like the product is available only for a limited time in order to put pressure on the consumer to buy the product, and then this offer keeps being repeated. So it is a commercial tactic, and this is something that is blacklisted. Provision of after-sales service in a language different from pre-contract. So the after-sales service also needs to be that utilized at contract stage. Creating an impression that a legal product can be sold and things like this. So you get the idea of what are the blacklisted practices. And there's a whole list of these, so you can go through them at your own pace when I send the presentation, including, for instance, making persistence and unwanted solicitation by phone, email, etc. Advertise to appeal to children to buy advertised products or persuade parents. Okay, misleading actions. This includes false information. So food products are advertised as containing no additives when in reality they would contain additives. Hotel rooms advertised as having a direct view of the sea when in reality they do not. And then that is false information. Then there are misleading actions. Misleading actions include offering a portion of chocolate in a significantly larger package, offering dry cleaning and making consumers believe ironing is included, used, sold as new. Now, if you are making an invitation to purchase, these are the main characteristics that need to be included in order to ensure that the invitation to purchase is not misleading and is not unfair on the consumer. The main characteristics of the product or service need to be included in this invitation to purchase. Okay, so now you are going directly to the consumer. Mainly this is done by email. The geographical address, identity, and trading name would be clear. The final price, including taxes and all additional charges, even when unsure, because sometimes depends on the country where something is being sent. Taxes may apply depending on the taxation in that country. You need to make that. You need to include it that taxes may apply. Specific arrangements for payments, delivery, performance, and/or complaint handling, and the right to withdrawal. Okay, so this is very much reflective of what we have been discussing during this presentation, and this is specifically what you need to make sure of when sending out a mail shot to your clients to invite them to purchase something. This is the information that is necessary to make sure that the request for purchase you are making is not ambiguous and is not unfair. Even though consumers treated as average should trade their target vulnerable groups, communication should be adapted. So in case of breaches, including that relates to unfair commercial practices, there is a basic fine of €2,350. you can get the contract completely annulled, and there is criminal liability. Criminal liability is not something that you will find anywhere else in consumer law, if you have noticed. But these kind of breaches are breaches where the trader is considered to have tried intentionally to cheat the consumer, and therefore criminal liability applies here. Unfair contract terms. So first we discussed unfair commercial practices, now the unfair contract terms. So basically what you need to remember in terms of unfair contract terms is that there needs to be a balance. It cannot be a one-sided contract. Okay, so it needs to be balanced in favor of the trader and in favor to the consumer. There cannot be disproportionate unfairness to one side and to the interest of another side. For instance, limiting liability resulting from personal injury from a defective product. Okay, that is something that can never be done. Limiting consumer rights or mandatory mediation system, as already discussed. Binding on consumers, but execution open to the free will of the trader. Excessive non-refundable deposits. Okay, so you get the picture here. It is the unfair terms are terms which are completely in the interest of one party, the trader, and completely against the interest of the consumer. They should be balanced and reasonable and proportionate. Now, I think we have reached the final stage, alternative dispute resolution and online dispute resolution. So, I have some questions, but then I will return to them. Let me finish the presentation. So, if you have an issue with a consumer, how do you go about resolving disputes? So now you have all this information available, but still problems arise depending on the situation, depending on the clients you are dealing with. How do you go about resolving them? So obviously you try to avoid disputes. Nobody likes arguing, trying to avoid disputes in the first place. Try to resolve directly with the consumer. So try to reason with the consumer, try to arrive to an amicable solution. If that fails, there is the ADR possibility and the ODR platform. Then following that, there are court proceedings. So first of all, on the second point, what I wanted to mention is that when resolving directly with the consumer, you can also get the help of the Competition and Consumer Affairs Authority, which usually tries to strike a balance between the trader and the consumer. Please also remember, because I have seen a number of cases where the trader, without knowing, would be talking to a consumer association. The consumer association is there to represent consumer interests. It is not the same as the consumer office, as the regulator, as the MCCAA. So sometimes traders think that they are dealing with the MCCAA when in reality it would be the consumer association. So in which case I would advise traders to get in touch with us in order to be guided and how things can be resolved and also seek the support of the MCCAA to try come between a bit the consumer and the trader, especially when things start becoming a bit difficult, to calm things down and try to strike a balance between the views. Because obviously the further you go, the more things get complicated. So, alternative dispute resolution, this is out of court. You would be using an ADR body, which basically it is a body that helps in the mediation and arbitration. So it helps in resolving things by hearing both sides, trying to reason, and then making a decision if necessary. The ADR is used for both online and offline purchases. and whether you are in the same or a different country. Okay, so it is available throughout the ADR. And the advantages of using ADR is they are easy to use, they are less formal, um, they are impartial. Okay, so you are dealing with someone who is impartial. They are inexpensive. They are efficient. There is a limit of up to 90 days to reach an agreement, and promotes goodwill because it is based on discussions and trying to reach an agreement. It is kept private to limit reputational damage, whereas when things get to court, sometimes there is a reputational damage. Also, the MCCA might publish something against the trader when the trader refuses to make amends on certain things and things like that. So this is a very private context. Um, and it is flexible in terms of solutions offered, which might not be possible in court. So in court, there are the remedies that the court can award and the way the court can deal with something. With ADR, it is more flexible, related to what the consumer and the trader agree. These are the ADR bodies in Malta. There is the general one, the Malta Arbitration Center. The MCCA have one as well, the Complaints and Conciliation Directorate. The Office of the Arbiter for Financial Services when the issue is related to financial services, specifically so insurances, banking, and things like that. And then there is the Malta Mediation Center, and these are the relevant websites. Okay. So there are two types of methods. So it is important that you make sure you know what type of method you are accessing. And there is the binding or the more non-binding. The binding ones, the non-binding ones are those based on mediation, trying to find agreement. Then if everything fails, you go to court. Then there is an arbitration that once both parties are heard, once one tries to reach an agreement and fails, sometimes a decision may be taken that binds whichever party it is to implement that agreement. So it is important when tapping into the ADR possibilities, you know what kind of ADR you are getting into. But then there is the ODR. The ODR is available through ec.europa.eu/ODR. It is mainly used to deal with online clients, especially helpful with language barriers. Okay, so the way it works is that you use this platform to communicate with the consumer, and the ODR platform helps not just with the mediation, not just with trying to reach a balance, but also in relation to the language barrier. So if the consumer is more comfortable talking in a certain language to be able to discuss, to be able to arrive to conclusions, this is something that can be done the same in our national languages or anything else. So if you sell online, you must provide your email address. Okay, we spoke about this. Contact form is not enough. You need to provide email address. Provide link from your website to the ODR platform. Provide additional information for its use and directed consumers to it in case of issues. Is something that is encouraged. Okay, obviously you make this information available. The consumer always has to agree how to resolve disputes. Okay, you cannot do this on your own. But providing this information provides the consumer, first of all, with visibility that you are very well organized. And these are platforms which are very sophisticated that you have access to free of charge. But also so that you try and mitigate things being escalated, because these platforms have proven to work. So this is how the ODR platform works. Consumer makes a complaint on the platform. Trader receives notification about the complaint. It can be the other way around, okay? You follow the link and register if you are not already registered to see the complaint. Select the ADR body you want to use if there is a choice. Customer either accepts or chooses another one. In case of agreement, the case goes to that ADR body. Then rules and procedures of the ADR body applies, but obviously everything happens online. You are updated via email and will be able to engage via the ODR platform. Translation tools are available for all the documents you send or receive. It is completed within 90 days. So they work very, very similar, the ADR and the ODR, but one is purely online, the other is physical presence. You can see the tutorial on the Consumer Law Ready website so that you can see how this works in practice. Okay, so with that, I congratulate you on completing the course. So we will go over it briefly to the website consumerlaw.eu in order to understand how things work. I have done the test myself as part of the training. And this is the certificate that you would be awarded. Now, first of all, I wanted, to go to the website. So consumerlawready.eu, this is where you would go into. This is the page that you would find. You select your country to get started. In this case, my country is Malta. And then you select whether you are a consumer law expert or else whether you are an SME and you want free access to materials and you want to conduct a test and you want to see the videos of all the complicated things that I have explained. There are very simple videos online. You choose Start Now. And that is where you will find the full resources. So, you can see how it works, how the program works, what is included in the program, the different sections that I have mentioned, the resources. These are the online resources and the local courses, which is the one that we are doing today. If you go into online resources, you will see that there are different modules. Okay, depending on the subject. This is on pre-contractual information requirements, the subject we start with. You will see videos to make it very, very simple for you to understand. And if you would like to go into further details, even greater details than what I have explained, there are the modules, okay, which are full of examples and which are very interesting, okay? Even if you have a specific issue with a consumer, use these as reference points, as reference resources to be able to understand how you can handle a specific case and what are the real rights that one has access to. Okay. So I have stopped sharing, but now I have a number of questions that I need to handle. A client purchased a gift over the e-shop and remarked that they wanted the gift delivered the next day, which happens to be a public holiday. Since it was a public holiday, delivery was not effective. Are they eligible for a refund? So I think when it comes to delivery, because it is something that might relate to the consumer's appetite, such as gifts, such as certain things that are time sensitive, I think something like this, it is important. It is important to make it clear what are the delivery conditions, and if you guarantee a next day delivery and the next day happens to be a Sunday or a public holiday, they need to wait till the following day to have it delivered. However, if someone has purchased something over the e-shop, then the 14 days apply, the 14 days cooling off period applies. So even irrespective of the delivery date, you would still need to refund the consumer. What happens when a product from another EU country is listed as having 6 months warranty only? The warranty that is applicable is 1 year. Okay, that is the legal guarantee. that cannot be reduced unless it forms part of the very specific requirements that would be listed as an exclusion. Okay. So what I suggest is you can go into the resources, go into the guarantee, and go into the full details of which products and services would be excluded. I can tell you that it is very, very minimal, the cases where they are excluded. And if it is an EU country, they are subject to EU law, and it does not make any difference which country they are based in. Voucher refunds are not acceptable, as you stated, but most airlines give voucher refunds for cancelled booked flights. Is this legal, or is it an exception due to COVID? Does this exception also apply to other providers? Now here, Carlo, you have opened up a bit of a can of worms. Now, first of all, in terms of flights, other specific consumer legislation might apply. So here, the package travel directive might apply, but obviously, if you are buying something directly from the airline, then it is not a package travel and consumer law only applies. Now, we have seen this practice, and even some member states have regulated at national level this practice, which is in reality an infringement of EU law, where they say that only vouchers are acceptable as a refund. In reality, they are breaching EU law. So you are still within your full rights to demand a full refund, okay? So, but obviously COVID has messed up things for everyone. In some cases, traders have told consumers to, for now, accept a delay, so a postponement, so to accept a postponement, and then possibly they can get their money back. But yes, in any case, consumer law applies, and in reality, you have full right to a real refund, not vouchers. If it is specified that in case of return postage will be borne by consumer, is this allowed? Is it legal to write this? So there are specific cases only where the return of postage can be put on the consumers. And yes, when this is the case, this always has to be put in writing. Most of the cases I mentioned, the trader has to bear the return of postage. But what we can do, Elaine, is to go into more details for you to explain exactly where this can be put on the consumer and how to write it legally. ADR and ODR stands for Alternative Dispute Resolution or Online Dispute Resolution. Okay, so the idea is that there is a dispute. Instead of going to the courts, you seek an alternative method, so the alternative dispute resolution, and then that same method is turned into online dispute resolution. If you sell online locally only, do you need to have a link to ODR platform? Yes, you still need to have a link to the ODR platform because it is something that consumers have a right to now. You are not obliged to put the full details, but it is good practice to still put the full details and explaining how the ODR platform works. Normally, it is much preferred to go that route instead of ending in a tribunal, and which is a much stickier situation. Okay. Mela, after the webinar, you can take the test in whichever point you want. So while the information is fresh, I suggest you take the e-test, but you have this at your disposal. Even if you want, we will be sending the presentation. Even if you want to go through it with colleagues and you do the e-test together, this is something that will still be accessible. The certificate is not related to CPE hours. The certificate is issued by the European Commission, but no, it is not linked to CPE hours. So the presentation that I was explaining will be sent to you by email on the email that you have registered with. You will not find it in the Consumer Law Ready website because this is something that we ourselves have adapted for the local context. But as I explained, use them concurrently. It is a complementary tool. Can you specify if the 14 days period applies for all purchased goods, example, spare parts? Yes, it applies for all purchased goods. Obviously, the spare part during the 4 days period cannot be fitted. Imagine there is a spare parts shop and you go visit the spare parts shop, and the consumer would look at the spare parts, they would analyze it, they would ask questions. That is as far as the goods purchased can be utilized, can be explored at the consumer's place. If it has been purchased online, yes, the 14 days always apply. For the in-store purchases, the company rules for exchange and refund, can they apply if no refund is allowed as per the company's rules? Yes, for in-store purchases, then it is the company's policy. Okay, there are no strict hard rules related to consumer law. You need to provide the full information for the consumer to make a knowledgeable choice. So if the consumer can prove that on purchasing, they did not have all the information that is basic, necessary in order to make the purchase, then the company policy then does not apply, okay? So the company policy for in-store purchases only applies when the full information has been passed on to the consumer. Okay. Can a trader ask for full payment prior completion of service? What happens if a consumer says, okay, these are different questions. Okay, there is nothing specifically by preventing the trader. There is nothing specifically disabling the trader for ask for the full payment prior to the completion of the service. But the consumer must be very aware when entering into an agreement that full payment must be provided prior. And in order not to be listed as a big contractual disadvantage for the consumer, there needs to be a good justification for this, okay? So not everybody now goes and puts in that full payment must be paid prior and everything, okay? And also the remaining parts of the law applies, okay? So if the service then cannot be completed, there needs to be refund of the service. What happens if a consumer settles the full payment of the service, but the trader then fails to comply and present the final job in a reasonable time frame? Okay. So it is very much dependent on a case-by-case basis. What this failure was due to, okay? So I think, Daniela, that the best thing would be to discuss any specific case directly, because obviously the trader being given the full payment and then failing to comply and delivering the final job is not something that is standard. There must be a very specific circumstance, and we can discuss this and see how consumer law applies and what redress methods can be sought for. What if the time frame is not specified on the contract, and what makes for a reasonable time frame? This is a very good question because it is very subjective. Reasonability is very subjective, so that is why I think that time frames when an issue arises. Okay, when it comes to delivery, you need to say what are the expected delivery timeframes. When it comes to repair and something needs to be sent abroad and then come back. For instance, I had a case myself. I had a problem with the phone. My phone had a technological issue, so it was not something that I myself created, and this phone went crazy. And I gave it to the provider to fix, and the provider told me I will need to send it abroad. The phone is very, very essential for your functioning. I was given a replacement phone, okay, so that I can continue with my basic functions. But then when 1 month passed, when 2 months passed, and I don't have my proper phone and I cannot carry out the functions specifically that I need, then that starts to go into the unreasonable. So it is always indicated that when certain time frames are expected, you reason these timeframes with the consumer. So at the moment, for instance, this gets a little bit complicated because of COVID and everything is a little bit delayed. You still should tell the consumers that normally something like this would take a month. But because of COVID, this is taking 2 months, it is taking 3 months, okay? And you assess how reasonable that is for the consumer, okay? So something might be very essential, something else can wait. And the consumer might be in a position that they can wait or they cannot wait. In case the consumer requests a visit to check and send a quote for a shutter door or AC or so, yet the supplier changed parts without the consumer approval on any quote, is the consumer still bound to pay even if it was beyond his budget as well? Now, the consumer is bound to pay for anything that the consumer has agreed to. So obviously it is important that at each and every stage you make sure that the consumer is aware of whatever cost might be incurred, might be necessary, and only make an agreement via a durable medium that the consumer has agreed to these specific alterations. Okay, so sometimes a visit might be done, an inspection might be done to check the works necessary, and then whoever it is sends, unless it is urgent fixes, very urgent fixes that need to be done, that obviously would be agreed there and then, and would be paid immediately. Yes, but if the consumer didn't yet, the supplier charged. The supplier should have some form of agreement, okay? Unfortunately, the supplier is very, very exposed. They can try to reason with the consumer to get them to pay, because obviously at the end of the day, the repairs have been done, the parts have been utilized, but the trader has put himself or herself in a very, very big disadvantage, in a very disadvantaged position, because there is nothing that is showing that the consumer has agreed to. Okay, so in that case, unfortunately, it is very much against the trader, and they need to find an amicable solution as much as possible. But obviously, there are ways to avoid these circumstances, and these should all be explored. It is not difficult to take some time and agree with the consumer and tell them, listen, I will provide you with the full information, then you see if you are comfortable with it or not. And that saves you a load of hassle after. Okay, so once again, please feel free to visit the Consumer Law Ready website, consumerlawready.eu, so that you can have access to the full resources, the full information. The videos are indeed very, very useful. Okay, and you can also have the test. I hope you found this information useful. We are here in order to provide further information as necessary and help you with any particularities, because things might be very particular in your cases and which cases you encounter, and we'll go through them as well. We also have a very good level of communication and relationship with the Malta Competition and Consumer Affairs Authority, and we can help getting them on board with certain complicated and specific issues that you would need clearance about. So thank you. I leave you with this. And should you be interested, my colleague has posted, we have a webinar targeting businesses on the latest government COVID schemes related to the tax deferrals, the moratoria on bank loans, the guarantee scheme, and the wage supplement, which will be very interesting. It will be held today week, okay? So should you be interested, please use that link to register. Thank you very much for now, and I wish you a good rest of the day.